Welcome back to another edition of Between Two FARS. I'm Warnke Miller here once again with the amazing Robert Tepfer, and we're continuing our ASBCA litigation series. Specifically, we're talking about witnesses and preparing your witnesses. In our last episode, we hit the two most important steps: getting to know your witness and telling your witness to tell the truth. Now we're getting to the next concept you really need to understand and prepare your witnesses. You need to prepare them emotionally for the process of being deposed, the process of giving testimony in a hearing. There's a lot to it, and if this individual, if your witness has never testified before, it can be overwhelming for them. So today we're going to talk to you about the things that you need to consider to emotionally prepare your witness to give testimony. What are your thoughts on this, Bob? How would you start?
Well, I think in the vast majority of cases, witnesses have not testified before. This is all new to them. And for some reason, they always think that everybody else understands and feels comfortable and that they're a newbie, when in fact, maybe they are, but most folks are. You don't want a witness that is so sophisticated because they've been involved in so much litigation that they're better than you are. But you have to sit them down. A lot of them are nervous because they're going to be under oath. They have visions of federal marshal taking them away. They have they're just good people who like to swear to things that are truthful and accurate, and so they worry about it a lot. And I've had a lot of those. And they sometimes you end up with, it's personality driven. Maybe for the last 25 years, they've been focused on getting to a higher position, sounding confident, knowing all the facts, being responsible and accountable for everything, and therefore they want to put all that, in front of whoever is asking the questions. And sometimes it's just an insecurity thing. And those can be very bad, because I've seen some folks, you could tell they didn't feel like they should have had the wonderful title that they had. So when they showed up, they overdid it on selling them that they were qualified and ready, and opposing counsel kind of ate that up. I've had witnesses that I had to calm down in that regard. As I talked to you before we recorded, I had one witness who showed up with a three-piece suit, and I wanted to downplay the role that that individual had and not get them in the spotlight, because I for a lot of reasons, not the least of which was the fact that I didn't think that they would do well, and they didn't. And I had to send them home to get a sports coat with patches and a tie to look a little bit less, in control. And so those kinds of considerations, you can't get that over the phone. That's part of the witness prep, getting to know that individual, getting a feeling for how they're going to testify, and that kind of thing. How alert do you need to be? How much prep do you have to have on specific areas? Okay. Yeah. It's all going to be very much fact specific and personality driven.
Presenting your theory of the case is often getting the witnesses to understand that how they present themselves folds into the government's theory of the case. So yes, if you've got somebody who wasn't in authority on this contract, even if they are self-confident and are the type of leader that always takes responsibility for the situation, regardless of whether or not it's their fault, you've got to get them to realize that that's not going to play into the theory of the case. The facts of the case are, you didn't have authority in this contract, you didn't do anything that authorized anything, and you don't need to come across as if you're taking responsibility for anything that happened, when in reality you had nothing to do with the facts of what was going on in the situation. And it's hard sometimes to get them to the mindset to testify to the truth in a way that furthers the storytelling of your case.
Now, you mentioned the theory of the case. You want to make certain that folks are consistent. You want to make certain that they buy into it. Maybe it's not the right theory. Maybe it's just inaccurate. Maybe there's a basis for settlement. A lot of times you get folks together and you discuss it because they will put pieces of the case together and somebody will say, you know, I forgot about that.
Yes.
We did have a meeting on that issue. Or somebody will say, you never gave direction to this individual, because I was at that meeting. And to the extent you get folks together, that's good. And to the extent, you know, I'm right up front with the theory of the case. This is what I'm going to say, and this is what I believe is the case. Anybody disagree?
Right.
Better you should hear that then you get into the case, and there's one witness that says, you know what, that's just not the way things unfolded. That's good to know.
Yes.
You know, okay, maybe there's another theory, maybe there's a time to settle. But unless and until you get those folks together, you know, the opposition will be able to find that out. You may have a valid basis for not paying, but maybe that's not it, or you didn't frame it right. But you need to find that out and find it out early. Okay, so that's part of the preparation, in my opinion, because you need to the personality, you need the facts, you need the other personalities, because this case is not just one person in most cases, it's several.
Yes, and you need sort of the team to have the unified concept of the facts and the truth of this case, and you're all working together to tell the story of the case, to have that theory of the case unfold in front of the judge. I want to talk a little bit about preparing your witness emotionally for opposing counsel, and what opposing counsel is going to throw at them. How do you prepare your witness for their interactions with opposing counsel?
Again, we talked about this before, and I think it's right. You have to sit them down and say, look, opposing counsel is not your friend. They have an ethical obligation to zealously defend or to put forth their case. And that means that they're going to try to find things you forgot, ask you questions that put forth their case in the best light. That's not bad. That's an obligation that they have. And so you need to be very cautious in how you choose your words, make them accurate, but make certain that you state what really occurred, because it's not going to be credible to say, maybe it would be better if I said this occurred, you know, or to choose words that color the case differently. And so you don't want them to be so nervous that they're incapable of speaking the facts, but at the same time, you want them to be accurate. You know, you stress to them that they have to tell those things that occurred and be accurate, and you need to make certain that they tell them and not be apprehensive about opening their mouth. Okay.
What about that opposing counsel who is overtly rude or appears to be trying to push the buttons of your witness? This would be more in deposition than in hearing, but how about emotionally preparing them for that?
I've seen that. I know you've seen that. Sometimes when they are doing their witness prep and talking to people, they'll be told, hey, bring this up. That's a real nerve. Well, better you should bring it up to your client if you can find out about it, or rather your witness, and say, you know, be prepared. They're going to try to rattle you, because all the information I gave you or direction to be cautious, to be accurate, you may lose it. And they would like that. Yes. So they're not your friend. So you know, when you talk to witnesses in preparation for the case, find out about other witnesses. Find out where the vulnerabilities are. Have they had problems? Do they not get along with other people? Maybe it's not surfaced any kind of administrative thing, but it's there and it can be brought up. And you need to, it's another reason why you have a very expanded discussion with people before you even do the specific one on the particular facts of your case.
In prepping witnesses for interactions with opposing counsel, it's a spectrum. You kind of want to, hey, they may be really friendly. They may be trying to get you to talk and finding things they have in common with you to loosen you up and to get you to have a free-flowing conversation. Be wary of that. They're trying to do their job. Their job is to elicit information from you that will help their case. So beware of that. Always be polite, but don't be overly friendly. Don't be joking with them. please don't use any jokes or humor in a deposition or in a hearing, because it does not transcribe well. And on the other side, if they're trying to upset you because they feel like if they can get you to lose your temper, you're going to say something that's going to benefit their case. Once again, be polite, be the adult in the room, be the calm one, but don't be overly friendly, and certainly don't be antagonistic or angry in any of your responses.
There's two things that I'd like to bring up. One is I always have the phone number for the judge when I do a deposition, because I've had some folks that would cross the line, in my opinion, with regard to being rude to a witness. Or if I was deposing, they claim that I couldn't ask questions, and that, you know, it's a very narrow area. You know, if it has a tendency even slight to support a matter, an issue, they're compelled to answer. If it could lead to evidence, they're compelled to answer. And they'll make some assertion, and so it's kind of like, okay, let's call the judge, and we'll wait. And I have done that. That's one thing that is nice to have in your hip pocket. If you can't locate the judge, if you don't have the phone number, the case, you know, the deposition can unravel. All you've got is a threat that I'm going to do this deposition another day, and you're going to pay for it, or your client will, because of your rude conduct and the way you've handled it. Another issue, something that you just brought up, not being your friend. There's two issues that relate to that. One, I always tell folks that when, if you're sitting in the room and you're there nice and early, and counsel comes in and the court reporter is not set up yet, you haven't gotten it set up yet, that this individual may attempt to start a nice friendly conversation and establish a rapport. Okay, it's not under oath, it's not being transcribed, but the fact of the matter is that rapport is critical, and it could lead to the, you know, finding out about other people. I've seen witnesses that they would, you know, be there, and counsel would show up, and they would have somebody else with them, and they would say, hey, you know, and they'd try to set up, we worked together 10 years ago. And, you know, how's that going? You know, did your daughter get into school like you thought, and everything? And it sets that rapport, and it's a kind of a friendship type thing. It's very difficult to be curt, short, focused when you're changed from that atmosphere to an atmosphere where you're testifying. They know that. That's why they're doing that. They're attempting to create a very friendly relationship. As you said initially, they're not your friend, and you don't want to let it unravel. Okay, that's just not a good thing to have happen. And so I try to get people to understand from the moment they walk in, the deposition has begun, notwithstanding the issue of oath or formal questions.
That's right. All right. So far in prepping your witnesses for ASBCA litigation, we've learned that you need to get to know your witness. You need to tell them to tell the truth, and you need to emotionally prepare them for testimony. Join us again next time between two FARS, and we're going to talk about some of the more functional nuts and bolts types of information that you need to convey to your witnesses.